My question, I have a question about the Hyde Amendment. So I gather from the briefing that there might be some situations in which EMTALA would require an abortion, but the Hyde Amendment wouldn't permit federal funds to be used to pay for it. And you said in your brief that EMTALA requires in other circumstances as well stabilizing treatment to be given that federal funds don't cover. Can you give an example of that? And am I right about the Hyde Amendment? And then can you give an example of that?
Yes, so you are right about both things. It is common under EMTALA that hospitals are going to have to provide care where there's not federal funding available. And I'll give you an example of a Medicare patient who goes in and his emergency medical condition means he needs a particular drug that's not covered by Medicare benefits. Still, the hospital has to provide him with stabilizing treatment and give him that medication even though the federal funding isn't going to pay for it. And that also applies to people who are uninsured, who aren't covered by Medicare in the first instance. The whole point of EMTALA was it doesn't matter your circumstances, it doesn't matter whether you can pay or not, it doesn't matter the particulars of your situation. This is a guarantee. You can get stabilizing treatment. I want to say, though, that I don't think there's any inconsistency between the lines Congress drew in EMTALA and Hyde. And Congress itself has recognized that these statutes address discrete issues. I'm thinking here of the provision in the Affordable Care Act that was exclusively about abortion, and there Congress said, nothing in the ACA displaces Hyde and the other federal funding restrictions on abortion, but also nothing in the ACA displaces EMTALA's requirement to stabilize. And that shows two things. It shows first that Congress recognized that stabilizing care can sometimes be pregnancy termination, and I think it also showed Congress's recognition that these statutes address their own distinct spheres. And one final point on Hyde, Justice Barrett. My friend isn't drawing a line based on Hyde either, because his point is even if a woman is on the brink of death and she goes to an emergency room and there are federal funds available under Hyde to treat her, still hospitals have no obligation under EMTALA to provide that care.
So what about the colloquy I was having with your friend about what stabilizing treatment entails? Let's imagine a situation in which a woman is, 10 weeks and is told that if you carry this pregnancy to term, it could have, consequences for your health, but you just would need to abort before, like, say, 15 weeks, something like that. So there's not an immediacy, so she's stable when she leaves the hospital. But in Idaho, there's no place else that she can go, at least until she's 15 weeks. What is the federal government's position then?
I think, if I'm understanding the hypothetical correctly, that she likely wouldn't have an emergency medical condition in the first place, because the definition of having an emergency medical condition is that without immediate treatment, you will reasonably be expected to have serious dysfunction of your organs or serious impairment of your bodily functions. And so in that situation where a woman is somewhat high risk, maybe she has certain complications where doctors can say there's some danger with continuing this pregnancy, I don't think that creates the kind of emergency medical condition that EMTALA is aimed at.
Okay, last question, and this is about the spending clause issue. So it does seem odd, and I think kind of what some of the questions are getting at, it does seem odd that through a side agreement between a private entity and the federal government, the private entity can get out of state law, right? So in another administration, would it be possible then, in reliance on the spending power, for Congress to say, any hospital that takes these funds cannot perform abortions, or any hospital, despite state law requiring a state constitutional amendment requiring abortion to be available? Is that possible? Or, with gender reassignment surgery? I mean, you can imagine it kind of going back and forth through spending clause litigation in ways that would be unusual.
Yes, I think Congress has broad power under the spending clause to attach conditions. Now, it doesn't mean that it's wholly unlimited. Obviously, Congress would be having to act pursuant to an enumerated power. It would have to comply with other constitutional limits, and so the law would have to be valid. The spending clause itself has built-in limits, things like relatedness and
so it would have to be acting pursuant to an enumerated power in forbidding gender reassignment surgery or abortion or those sorts of things?
Oh, no, I just meant that it would have to be valid. The spending clause itself would be enough, yes.